The case of Troxel versus Granville starts with Tommy Granville and Brad Troxel, who were romantically involved and had 2 children together. They never married, and they split up in the early 90s. Brad Troxel passed away. But Brad Troxel's parents wanted to continue visitation with their grandchildren even after their son died. There was a dispute about how much visitation rights these grandparents should have. And this litigation would go on for the better part of a decade until the case finally ended up in the Supreme Court of the United States. The United States Constitution, neither in the Bill of Rights, nor in the 14th Amendment, nor anywhere else, explicitly refers to the right of parents to direct the upbringing of their children and to control their education. But nevertheless, for a century, the court has held that it's a fundamental right that parents have to be able to be the primary determiners of their children's upbringing and their education. But one of the things about parental rights that has been controversial is that it is seen as being connected to substantive due process, which in some people's minds is difficult to justify. Substantive due process seems to give judges the power to enforce rights that aren't in the Constitution. It seems to give judges the power to overrule legislation that Democratic majorities have decided on. And that was one of the issues that actually divided the justices in Troxel versus Granville. Troxel's argument was the Washington statute that was at issue doesn't violate the federal Constitution, doesn't violate the principle of parental rights. As they pointed out, there are lots of statutes all over the country that provide, for example, for grandparent visitation under certain circumstances. Tommy Granville would argue Washington's statute goes so far as to really be inconsistent with any meaningful right of parents to direct and control the upbringing of their children. We ended up with 6 different opinions in Troxel versus Granville. It can be tricky to parse what all the different opinions are saying, but the bottom line is that there's a broad agreement among the justices that the Constitution does provide meaningful protection to parents' constitutional rights to raise their kids, and 6 of the justices agreed that the Washington statute had been applied unconstitutionally in this case. Justice O'Connor's plurality opinion is seen as being grounded in the Due Process Clause of the 14th Amendment. Justice Scalia's opinion was very clear in expressing his doubts about substantive due process as the home for parental rights. Justice Thomas, in perhaps the most interesting opinion, suggested that another provision of the 14th Amendment that deals with the privileges and immunities of citizens of the United States, that might be the textual hook, if you want, for parental rights. It seems to me that the disagreement between Justices Scalia and Thomas really points all of us to a fascinating debate. And that is, if we believe that parents should be the primary caregivers of their children, that they should have the primary choice about where their kids will be educated, then the question arises, if that right is not mentioned in the Constitution explicitly, what do we do? One option is to say that means it's up to the legislatures. Another option would be to look, as the court has for about a century, to this idea of substantive due process. The thing is, there's dangers with that approach, because then you have to ask who gets to decide which unwritten rights are fundamental and which ones aren't. Another option is the one, again, that was hinted at in Justice Thomas's concurring opinion, and that he has developed more in his jurisprudence since Troxel, which is to say that we might have originalist reasons for thinking that those who ratified the 14th Amendment believed that the Privileges and Immunities Clause, not the Due Process Clause, but the Privileges and Immunities Clause, did authorize courts to protect certain fundamental rights that were widely recognized at the time. That seems to me to be the most promising approach.